Now, defined benefit plans are entirely different. Defined benefit plans are about getting some type of benefit in the future. In other words, there's no cash value right now in today's dollars necessarily. It's about years of service to the company, payroll or amount of pay in terms of calculating your benefits, and a bunch of other actuarial type of calculations. But again, defined benefit plans are not something that normally has a cash balance, so certainly cannot equalize a defined benefit plan and a defined contribution plan. Now, there's a very rare circumstance where you could come close to that, and that's if you want to incur taking a defined benefit plan and actually getting it at present value, doing a pension valuation as of a certain date, so that way you bring a defined benefit plan based on in today's dollars, and then you have a value to assign to it. And a lot of times, the only times that's done is if the parties are generally in agreement that they don't want to touch the pension holder's pension, but they do want to assign some value to it so that the other party gets some credit either through their own defined contribution plans or their own defined benefit plans. So if that's the case, then you can value or have valued a defined benefit plan to come up with today's dollars. But the real issue is not earnings and losses. Matter of fact, I've seen agreements where they talk about pension accounts, which are defined benefit plans, and then discuss how earnings and losses are going to be included or excluded. And that only is defined contribution plans. Never say anything about earnings and losses when it comes to defined benefit plans, because it doesn't matter. It's non-existent. But what is existent, and one thing I just want to spend a minute on, is survivor benefits. Survivor benefits, I cannot tell you how important it is. This is probably the most litigious area. If you hear about attorneys getting sued or somebody getting sued for QDROs in any capacity, it's about almost inevitably something to do with survivor benefits. And here's why it's important. One is, a lot of people, once they say, well, I'm getting 50% of my wife's or my husband's retirement, but they don't retire for 10 more years, I'll worry about the QDRO in 8 years, and I'll still have 2 years ahead of time, so I don't have to worry about it. Well, first off, there's a couple of things you need to know about that. One is, certainly after your divorce, you want to do it right away. If for no other reason, just worry that your spouse may get remarried, because if a spouse gets remarried or the spouse gets hurt and is enforced into an early retirement, or the spouse dies, any of those life-changing events will certainly impact on some level the benefits received to the alternate payee, the spouse receiving the benefits, if there's not a QDRO in place. It's certainly not going to make it an easy process. So any of those life-changing events like life or like death, remarriage, or early retirement because of an injury or disability is certainly going to change the dynamics of that. If a QDRO is not in place, because if a QDRO is in place already, even if the retirement doesn't take place for a long time, that's why you get it done right away, then you have already set up the protections necessary so that if those things do have, then you don't have to worry about it nearly as much. So certainly want to make sure that QDRO is done right away. The only other thing that I'll say on defined benefit plans is not only are the things we talked about life-changing in terms of benefits, but there are a lot of plans that say, you know, the elections need to be changed to reflect this QDRO by so-and-so within 2 years or within 1 year of the divorce or something. So you have to be careful. Not only do you have the life-changing types of things, but then you have the plan over here that are governed by ERISA, these plans that have something in there that they put in their own time frames. If you don't know about those time frames, you haven't been told about those time frames, you can't just let years go by, because I've seen many plans that have, you know, 1 year after the divorce, the QDRO must be done, or 2 years after the divorce, the QDRO must be done. If not, you waive your right to this survivor benefit or something. And the reason that's important is the person receiving the money from the employee spouse, so they're getting a benefit as a result of the employee working. Now, I understand they're getting that benefit because they were married and that's part of the divorce process, but you want that spouse, if possible, if the plan allows for it, most of them do as long as you do it early enough, meet the deadlines, can continue to receive that benefit even if the employee spouse predeceases her or him. So in other words, you just don't want, by missing a deadline or not doing something in a timely fashion or not addressing something in the settlement agreement, that the spouse that's supposed to receive the money from the employee spouse, so the alternate payee we're talking about, now only gets a benefit until the spouse retires or until the spouse dies. So what if you have the case where you have a spouse who's in poor health, or maybe even older working spouse, so 15-20 year difference in their ages. This spouse dies, then the alternate payee spouse goes on living 20-25 years after, but they did something wrong in their timing and the not having the proper protections or language in the settlement agreement, and that particular spouse only received the benefits till this spouse died. So she or he may have given up 20 or 30 years of actual retirement benefits that can't be undone. And that could be because somebody remarried, somebody made an election at retirement, an early retirement, before a QDRO was ever put in place, because those elections are going to govern no matter what the family court judge says. It's going to go by the elections in almost every plan, what's been set, and that law is pretty firm across the country. So just because of that, your client could have potentially lose out on 20 or 30 years of benefits, monthly amounts. Now you can obviously see why this is the most litigious area, why a lot of divorce attorneys refer out, and why I keep a lot of malpractice insurance. Because even though, knock on wood, I have never had a claim, even I worry about it. And I'm not the one writing the settlement agreements. I'm only facilitating what's already been agreed to in the settlement agreement. My challenge comes into place when nothing has been discussed in the settlement agreement. Then I got to go back to the attorneys and try to figure out if there can be an agreement reached, and if we can do it without going back to the court and all that kind of stuff. So all of this can be eliminated, obviously, if you got a pension or a QDRO professional earlier on in the process, or that would be possible. Now, I know that finances are limited in some cases, so you got to weigh the cost versus the benefit, but just a lot of this stuff can be done by the divorce attorneys, just knowing, basically having a good understanding of the types of plans and what can be done and what has to be included. So I've actually made a checklist, and it's available on my website, but if you email me, I'll certainly send it to you. It's a one-page checklist, talks about defined benefit plans, defined contribution plans, and lets you know what to be looking for depending on what type of plan is in place. And it's a real handy thing you can fold up, carry with you. In today's world, you can probably scan it right onto your iPhone or your mobile device of some sort, but it is something that you could carry to. I know that many mediators have this at their mediation table to talk about, and so I'll certainly make that available to you. I hope you've liked these video series. This is the second video. As you can see, if you missed video one is going to be right here on the same page. You can click and watch that video. There'll be another third and final video coming up in about 6 days or so, and I hope I'll look forward to you there and seeing you there. And then we have our, the webinar that launches in October. It's a webinar you watch at your convenience and all that good stuff, and provide feedback that rolls into a second webinar and all that good stuff. So certainly I'll tell you more information about that. But right now, just enjoy this content. I hope it's bringing some value to you. And if you have any comments or anything, certainly call me directly. My name is Robert. Email me, robert@qdronow.com. And I'll look forward to seeing you on the next video. Thanks.